Greetings, everyone. It's Tia Diva with the Diva Lawyer Social Club, coming to you today from uh, coming to you today from a new media source via StreamYard. Presenting today with Mentality Media 24/7, and hopefully they will be joining us soon to join in on the conversation for today. First of all, happy Love Day for everyone who celebrates the holiday, and I hope everyone is having a great Valentine's Day today if you do celebrate. Um, so today I'm going to talk to you all about the how to interact with the police and how to deal with a police stop in the event that you are stopped by the police, or if you are detained by the police, or if you are actually arrested. So there's three different levels of police interaction that most people will or possibly encounter as part of a situation. So police can approach you and stop you and question you, but if they don't have reasonable suspicion or probable cause, you can technically just carry on about your way and tell them that you don't wish to talk to them, especially if they're just stopping to talk to you and ask you anything. People think that the police can only talk to you if they're trying to give you a ticket or trying to arrest you or give you a problem, but that's not necessarily the case. Sometimes police will just try to stop you to see how far they can get with you, and you are under no obligation whatsoever to engage with them in that situation. So then there's also another situation where the police can detain you. So you might ask them, look, am I under arrest? And they'll say, no, you're being detained. So that sort of throws a lot of people off, because what does that really mean? If you're detained, that technically means you're not free to leave. And then at that point, they may start trying to investigate you and question you. But even at that point, you still have no obligation to talk to them, to incriminate yourself, to have any exchanges with them, especially if you do not have an attorney present. So at any time, you can indicate that if you're going to be questioned by law enforcement, that you need to have an attorney present. At that time, all conversation must stop, all questioning must stop. Then we have the third level of a police encounter, where you're actually arrested, whether you spoke with the police or not. Usually, if the police are coming to arrest you, they're probably going to arrest you regardless of anything. So once you are arrested by the police, they will then take you down to the police station and probably put you in a room, probably come into the room and tell you that you have the right to remain silent. Anything you say can and will be used against you in a court of law. And I've seen so many times where I have seen people sitting in that room in handcuffs, and they're having these Miranda rights read to them, and they do not listen to what is being said at that time. So if you're at the point where you are in a police station in handcuffs and being read those rights, that is definitely a good time to really think about what is being told to you and probably exercise your right to remain silent, request an attorney. Again, once you request an attorney, the questioning must cease. A lot of people will think that for children and juvenile cases, that if they ask for a parent, that they have to provide a parent to be with them while the police question them. However, that's still not advisable at all times. Anyone should always request that the police, that an attorney be present before they answer questions of law enforcement. And I will get into the situation with that in just a moment. First, let's go over the Miranda rule. Now, I refer to this Miranda rights rule as the STFU rule. In other words, shut the F up, because so many times I see a lot of people just bury themselves because they do not understand what that rule says. They're not listening to the police officers when they're reading them that rule, or they just, for some reason, choose to talk to the police or talk to law enforcement officers without an attorney present. And people need to really understand how this rule is like so important to try to practice and abide by, because as the rule says, and it's tickling across the screen at the bottom. We can read it along together so that we get a full understanding of what that rule says. It says you have the right to remain silent. Anything you say can and will be used against you in a court of law. Now, I don't know what people don't hear about those words when, especially when they are in an interrogation room and being questioned by the police and are being read these rights under no uncertain terms. A lot of people will say, "Oh, they didn't read me my Miranda rights," but it's usually right there on videotape. So it's important that even if they don't read you Miranda rights, that you remain silent, because just note, it's not always necessary in every situation that the police have to read you Miranda warning before they arrest you or as a pretext to arresting you. The police can arrest you and not read you Miranda rights. If they have sufficient probable cause that you have committed a crime and the crime doesn't really involve you providing a statement, oftentimes they will arrest a person and not question them, and therefore Miranda does not apply. Because in order for Miranda to really apply, you have to be in police custody and you have to be interrogated. And if one of those elements are missing, it's not always required. So, for example, say you're driving with a pound of marijuana in your car and you get pulled over and the marijuana is in plain sight. The police might just have you step out of the car and not say anything to you at all. They might ask, "Oh, is that your marijuana in the car?" And some people will say yes, some people will say no, some people will remain silent. But if you do remain silent and they don't even question you about the marijuana in your car that is in plain sight, they're going to arrest you most likely and take you into jail without providing you a Miranda warning. And I get many times when people say, "Oh, they didn't read me my Miranda rights," thinking that that will get their case thrown out or something, but that's not how it works. You will the ramifications for law enforcement not reading you your Miranda rights is that in the event that you make a confession or make a statement that will incriminate you as a part of their investigation, then there's a possibility that you can get the statement suppressed and thrown out. And if that's the only evidence that the law enforcement has to support their case, then it's possible that your case gets dismissed because they did not read you the Miranda rights. However, if you're not in being questioned, or you're not in police custody at the time that you make the statements, then Miranda sometimes doesn't apply. So this is another reason why it's really important to understand and abide by the Miranda rule, also known as the STFU rule, shut the F up rule, because there's so many ways that they can use your statements against you that you might not even be aware that you're making a statement that can later be used against you. A lot of times people don't understand that there's various laws that even though you think you're innocent, you might incriminate yourself because you're actually not. Like, for instance, with driving under the influence cases in California, many people believe that you have to have a 0.08 blood alcohol content before you're going to have problems with a DUI case. However, if the police comes up to you at a traffic stop or at a DUI checkpoint and ask, "Oh, have you been drinking today?" then that may lead to you saying, "Well, I drank 3 or 4 hours earlier," thinking that that's not illegal to do. However, there is a provision in California law, whereas if you there's a provision under California law that you can be charged with a DUI for just merely drinking alcohol and being under influence of alcohol and driving a car without the need to have a .08 breathalyzer reading. So even if you aren't over .08, but you are driving recklessly or there's suspicion that you're violating traffic laws, they can use your admission that you have been drinking earlier against you to arrest you and charge you with a DUI offense under a different California provision. And let me just make a disclaimer. I'm licensed to practice law in the states of California and Florida. So everything that I'm discussing right now pretty much pertains to the state of California. Various states will have different laws. So it might be best to just get up to speed on the particular laws in your state. And just keep in mind that I am talking from a perspective as a California attorney about how everything works in the state of California. But with that being said, again, let's review the Miranda rule, otherwise known as the STFU rule. You have the right to remain silent. So that means don't answer questions. A lot of people feel, and I've been in the same situation, you feel that you have to speak to the police. If they're questioning you, you are obligated to answer their questions. And that's when people find themselves in some issues. So a lot of times, if we go back to the different levels of a police interaction, if you're just pulled over at a traffic stop, you do have to make the decision if you're going to be difficult or if you're going to be cooperative. Usually, if you're the driver of the car and you get stopped at a police traffic stop for a traffic violation, you should provide your license and your registration, your proof of insurance, and that should be that. The police officer is either going to write a ticket or give you a warning, and that should be that. So at that point, I mean, if we've all been in situations though where the police have started questioning you, like, where have you been? What have you been doing? This is where you probably want to pause and just kindly advise the officer, look, if I'm going to be interrogated, I need to have an attorney present. Am I being detained? Am I being arrested? Or am I free to leave? And again, at that point, they should stop questioning you if you advise them that you will not speak to law enforcement without an attorney present. And so at that point, you just have to really gauge what you're going to say or not say in order to deal with a minor traffic stop, but always keeping in mind that anything you say can and will be used against you in a court of law. I was just recently stopped by the police officer for allegations that I was talking on a cell phone. And he just quickly came up to my window, was like, who are you trying to talk to on the phone? I'm just like, I don't know what you're talking about. So, but that was to get me to just tell him my own self and be like, oh, I was just talking to him, or no, I was just trying to use it to find the GPS, but see, that's still a violation. So in California, it's hands-free. So if you have a cell phone in your hand and you admit that you had a cell phone in your hand because you were looking to do X, Y, and Z, then of course they can have more grounds to have evidence stacked against you. So this again is why it's important to really understand the STFU rule and try to abide by it. As far as again, and once you get to the third level of police interaction, where you're sitting in a cell interrogation room in handcuffs, or even not in handcuffs, but if you're getting read your Miranda rights, at that point, it's probably really important to advise the officers that you cannot speak to them without an attorney present. And at that point, the interrogation needs to stop. Now, I know a lot of people are like, well, I just want to talk to the police so I can get out of jail quicker. Or, I don't have an attorney, so I don't know, I will be sitting here forever. Again, the police officers need probable cause that you committed a crime in order to arrest you. Then they will pass their information on to the district attorney or prosecutor's office for a determination on whether there is sufficient evidence and sufficient probable cause to keep you keep you detained and charged or to set your bail, things like that. Now, most of the time, if you are not committing like a serious felony or a violent felony, you're going to get a bail or you're going to get released on your own recognizance. Especially in California, they've gotten to the point where for many offenses, especially the minor offenses, people are going to be let out of jail within a couple of days on their own recognizance. But of course, if you're charged with more heavier cases, you might end up looking at high bail and being in jail for a while. But at the same time, if you're looking at a situation that you're going to have a $1 to $2 million bail, $100,000, $50,000 bail, it's probably best that you definitely abide by the STFU rule and just demand an attorney, because if your bail is going to be that high, you're probably going to have issues and you're probably going to be in jail for a while. And there's nothing that you're going to be able to say that's going to change that. So it's best that you just practice remaining silent and demanding that you have an attorney present if you're going to be interrogated. So that's the first part of the rule. Then it says, I'll reiterate the second part that says anything. So this is so true. I mean, I've seen so many cases where anything somebody has said has been taken and used against them as evidence in a case. And then, I mean, they've said it, so there's no unringing the bell at that point. So I've seen many situations that were really drastic just because somebody started talking and they just didn't understand that the more you're saying is the more that's burying you. I saw a case where a man was charged with murder, got a $2 million bail for admitting that he was under the influence of alcohol and causing a piled up car crash that happened about 10 minutes after his car stalled on the highway. So this person wasn't even actually responsible for, or he wasn't the person that directly caused the injuries that killed a person in that situation. But ultimately, he was the one charged with murder because he just was saying everything and just talking about everything. And they used all of that against him in every single way they could possibly find. And I mean, he had to endure fighting a murder case because, I mean, what they're doing when they're asking you questions is to gather information so that they can put it into their formula to determine what they're going to charge you with and how high your bail is going to be. And just on another note, just keep in mind that even though you don't speak to the police and that you choose to exercise your right to remain silent, that does not guarantee that you won't go to jail. Again, if they have sufficient probable cause evidence to arrest you, or if they have a warrant to arrest you, that's probably going to happen regardless. So at that point, what you don't want to do is provide additional ammunition for them to stack against you and make your bail higher, make your possible prison sentence longer, make your charges at the max. Because again, they will charge as much as they can possibly charge based on the facts and evidence that they have. And the more that you give them those facts and evidence, the harder it's going to be for you to leverage a decent resolution to your case or a dismissal. So this is another reason why it's very important to try to understand the Miranda rule and to understand your Fifth Amendment right, and just always try to practice exercising those rights, the Fifth Amendment and the Sixth Amendment, and always ask to speak to an attorney if you are going to be interrogated. So, and again, it's not a guarantee that you won't go to jail. Many times, though, you won't go to jail. I've had many other situations where the police have sent someone a letter saying, you need to come in here and talk to us. And they contact an attorney, and, you know, the attorney advises the police officers that the client wishes to remain silent. And then at that point, if they don't have sufficient evidence, you know, no cases get filed, nobody gets arrested. But again, just because you do exercise those rights does not guarantee that you will get arrested. Just understand that you shouldn't feel pressured into just waiving your rights because you're concerned about money issues or the fact that you might not have an attorney at the time. So this is why I feel a lot of people probably go ahead and just voluntarily waive their rights, thinking that if they talk and if they just explain things or try to explain their side of the story, that that's going to make their situation better, because they don't feel that they're going to have an attorney or access to an attorney or access to bail money to get out. And so most people, when they get arrested, they just want to get out. But this is where you have to just pause and really consider that you might end up being charged with something more drastic or being stuck in jail even longer because you gave up information that you have a right to remain silent about. So, and just always also know that if you are charged with a criminal offense, you will be appointed a public defender if you cannot afford a private attorney. And I mean, it's always just very good to make a point to go out into your community and maybe schedule some consultations with a couple of lawyers that are in your area, so that you are familiar with some attorneys, that you have their phone number on deck. Most attorneys will charge very minimal for a 1-hour consultation, or some attorneys offer free consultations. That way you can just go and talk to the attorney for an hour or two about anything, and make that connection, make that relationship, so that you have a resource to rely on, that you don't have to worry about, oh, I got to try to get myself out of this situation because I don't have an attorney. I don't know any attorneys. And, I don't know when they'll appoint a public defender to me, or whatever makes a person decide that it's more beneficial somehow to speak to the police, as opposed to remaining silent and waiting until you have legal counsel to advise you about what to say or what not to say, or what to do, or just to handle the case. So anything you say can and will be used against you. And that's not can, maybe it might, it says can and will. So those are pretty strong words. They really tell you up front, anything you say, not some things you might say, anything you say can and will be used against you, not for you, against you. So again, it's really important to read the rule and understand what it means and what it is saying. And if anyone would like to pose any questions at this time, I can open the floor up for any questions or comments. Let me just check the room to see if anyone is present yet. And bear with me, this is my first time using this streaming service, but it is pretty interesting. I just need to get the kinks out. Okay. So again, we're here today talking about how to deal with police interactions. And I know the title of the show is The Black Person's Guide to How to Interact with Law Enforcement. And of course, this video is open to everyone. The information can be useful to everyone, regardless of race. However, we do know that it's generally a lot of Black Americans who face these problems more so than other people in this country, that many Black people have more encounters with law enforcement than anybody. And also a lot of Black people might not have the access and information to attorneys, to people who can tell them this information and who can assist them with this information. So this is why I specifically titled this video to Black people, but of course, the situation is the same for everyone. Another benefit of abiding by the STFU rule is that you limit your escalations with the police at that point. Okay, because we know many of us have been in a situation where a police officer will just come up to your car, with the attitude problem, and trying to provoke you to have to say something, and trying to rattle your nerves, usually for no apparent reason. So your first inclination is to just, try to have a battle of egos and try to, get into a conversation. That's also another tactic that they use to get people to talk, though, when they should be silent. So again, if you practice being silent and just pausing while you are interacting with the police officer, that also could potentially de-escalate a situation. If you're not answering questions, if you're not engaging with the law enforcement officer beyond what they have the ability to do, as far as if it's a traffic stop, they have the right to get your license and registration and your proof of insurance. Okay, but there's no purpose to engage with them beyond that. And if you are remaining silent and not saying anything more than what you need to say, that situation can't get out of hand. I mean, even if the police officer is being belligerent or difficult or have an attitude, if you're just silent and officer, am I being questioned? Am I under arrest? Okay, I need an attorney present if I'm going to be questioned. What else can they do at that point other than just go crazy overboard? And I mean, I know that many Black people do have a concern that if they do try to stand on their rights, that they will face death or beatings or more problems. But I mean, I don't think we've had situations where we have seen what will happen in the event of a Black person or anybody just not engaging with the police while they're acting belligerent or trying to provoke a response. So I see a lot of videos where people are just engaging with the police and going back and forth and, oh, I know my rights and you're not going to, and bringing it up when you could just tone it down. And then at that point, what can they do? Of course, if you escalate a situation with them, that does give them grounds to try to say that, oh, I fear for my life. I'm going to snatch this person out of the car now. I'm going to do whatever because, I mean, you have also a freedom of speech. So you should not be prohibited in being able to, speak to the police if that's what you choose to do. And you should not be killed or beat or punished because you say, you get into an exchange with the police officers. But you can practice the STFU rule and minimize that situation as well so that it never escalates to that situation, and maybe it will help you save your life. And that also helps you stand on your rights and to provide you with leverage in the event that you encounter charges at a later date or, you end up having a criminal case. So again, I cannot reiterate the need to understand this rule and to try to abide by it. I see so many cases where people really cause problems for themselves, just not abiding by this rule and saying innocent things that they think will actually help them. And in the long run, it actually hurts them. It takes away the leverage you might have in order to try to resolve your case. If the prosecution feels they have sufficient evidence and strong evidence against you, they then have no problem going to trial and, presenting their case to the jury. So if you minimize that situation and don't offer them additional strong evidence to work against you, then you can save yourself a lot of time and agony and pain as well. So again, I'll leave the chat open for the next 30-40 seconds. If anyone has any questions or wants me to address any other particular topic, we'll be rounding up in about a minute. And for all of you all who are watching this through YouTube or through Facebook at a later date after this live video ends, please feel free to leave any comments or questions in the comment sections of the YouTube premiere of the video or on the Facebook premiere comment sections on Facebook if you have any questions about this video. Also, if you're watching this video via YouTube at the Diva Lawyer Diaries, please subscribe to our channel, the Diva Lawyer Diaries. We have various videos that come out on a regular basis about a variety of things, legal tips, travel, dating advice, dating tips, dating conversations, and beauty and fashion information. So please subscribe to that channel so you can be notified when we are on YouTube or when we post one of our series videos on YouTube. And also like the video at the Diva Lawyer Diaries channel. If you're watching this on Facebook, please like the Facebook post and also hit the notification bell on YouTube so you can be notified when we have future videos coming soon. Everyone have a beautiful love day, and I hope to see everyone soon.